Hello guys, this is Olayeni Dear Kolola Daniels, popularly known as Dear Ko Spectre, and welcome to another episode of Dear Ko Talks Law. On today's episode, we are talking about some of the Nigerian cases in relation to privity of contract. In my last episode, I discussed the evolution of privity of contract. I discussed the part 1 and part 2 of privity of contract versus consideration, and also the introduction of privity of contract. And each of these cases, we've discussed about 5 cases: Price and Einstein, Tweedle and Atkinson, Dunlop versus Selfridge. We've discussed Beswick and Velswick, and we also discussed the Silicon case. Now, in each of these cases, they were all English cases, and we are like, okay, let us even look at the Nigerian cases. What do our Nigerian judges, what do they have to say in relation to this principle of the doctrine of privity of contract? And so we go to our lecture. But before we start, if this is your first time of coming to my channel, then I want to say a very big welcome to you. Thank you so much for coming to my channel. Please make sure that you click the subscribe button and make sure that you click the notification bell, so anytime I release a video of this nature which is going to be of interest to you, you'll be one of the first set of people to watch that particular video. Also, don't forget to share with your friends and colleagues and any other person that you know would be interested in this video. Lastly, don't forget to follow me on Instagram and on LinkedIn at Dear Kolola Daniels for LinkedIn and Dear Ko_Daniels for Instagram. Thank you so much as you do so. We then go straight to our lecture. So today we'll be talking about the first Nigerian case of Chuba Ikpeazu. Chuba Ikpeazu versus African Continental Bank 1965 case. And so what is the fact of the case? The appellant entered into an agreement with one MOD, a debtor of the respondent bank, under which the appellant, who at the time was the bank solicitor, was to run MOD's business with the intention that all proceeds should be paid into the bank until MOD's debt was completely liquidated. The appellant managed MOD's business for some time, and under a new agreement with MOD, he handed the business to the latter without the knowledge of the bank. The bank now sued the appellant as guarantor of MOD's debt, about £28,000, relying on a deed under seal containing the agreement between MOD and the appellant. So we need to understand what's currently going on with these facts. We are saying that we have the appellant. They are solicitors, right? Good. Now the solicitors entered into an agreement with who? With MOD. Now, the solicitors had entered the agreement saying that they are going to run MOD's business, right, until MOD was able to pay the money it owed to the bank. Bank is a third party. Can you look at that? Let us read the fact again. The appellant entered into an agreement with MOD, right? MOD is the debtor of the bank, right? No problem. Under which the appellant, who are the bank solicitors, right, was to run MOD's business. So the appellant, who is the lawyers who entered the agreement with MOD, was supposed to run MOD's business. Why? With the intention that all proceeds should be paid to the bank until MOD's debt was completely liquidated. So what we are trying to say is that the bank here is a third party, but the bank is mentioned in the agreement that, okay, solicitors, so take control of MOD's business. Who are the parties to the contract? Solicitor and MOD. Abi? And then who is the third party? The bank. The bank is supposed to get the proceeds which MOD was paying him, but it is the solicitor that is running the business, right? So we can see how the bank is just a third party and not privy to the contract. Now, the appellant managed, that's the solicitors, managed MOD's business for some time, and then under a new agreement with MOD, another agreement, he handed the business to the latter, that's MOD, without the knowledge of the bank. The bank now sued the appellant, that is the solicitors, as guarantor of MOD's debt, about £28,000, relying on the deed under seal containing the agreement between MOD and the appellant. So this is what is now going on. Now the solicitors gave the business back to MOD. You know that the contract was that the business will not be with MOD. The business is with who? The solicitors. And the solicitors were the solicitors of the bank. Good. Now, the business was supposed to be with the solicitors. The solicitors were supposed to run the business and pay the bank. Don't forget that MOD was owing the bank. They were supposed to pay the bank how much? £28,000, which is a whole lot of money. Do you understand? Now, what did solicitors do? After the solicitors got some of the money, they now had a new agreement. And what was the new agreement? The new agreement was that they were supposed to give the business back to MOD. And the bank was like, what's going on here? What happened to the previous agreement? I'm a party to the previous agreement. You have not honored the previous agreement. And now they are going to court. So, on that previous agreement, where the solicitor was supposed to give the money to who? To the bank. Can the bank now sue? That's the question. On that agreement, even though the bank is just a third party, a jus quaesitum tertio, can the bank sue? Do you get? And then what was the judgment of the court? The Supreme Court held that not being a party to it, the bank could not acquire rights under the deed. Can you see? The bank is not a party. The bank was mainly mentioned as a third party. The bank is not a contracting party. The contracting parties were the solicitors and MOD. The bank is just a third party who was supposed to collect the proceeds which was owed to him by MOD. But since the business is controlled by the appellant solicitors, what is going to happen? The bank was supposed to collect their proceeds from the solicitors. Do you understand? So now the solicitors can't run the bank streets. You get? The solicitors now collected some part of the money, and then because they are sensible, you know, lawyers, they are sensible. They've seen that, oh, this one they are not privy. Put the money inside our pocket, and they now come up with another agreement when they gave MOD back their business. And then the bank now sued the solicitors to collect the money. And then the solicitor said, my lord, but the bank, they did not furnish any consideration. They might be privy well enough to be the third parties, but they are not contracting parties. You know, in as much as they are privy well enough to be the third parties, if they are not contracting parties and if they did not furnish consideration, my lord, they do not have any right to institute this action. And the judge said, yes, solicitors, we agree with you. Where the party mentioned in an agreement is privy by virtue of being mentioned, if he has not furnished consideration, he will not be able to enforce that document. Do you understand that? And then we go to our second case. In this second case, there was something I did not understand. I don't know if the lawyer, I felt that the lawyer should have gone through my class on privity for the lawyer to be able to come up with this argument, the lawyer for the appellant, because I read the judgment and the case itself, and I was like, are you sure you don't need a little bit of tutoring on contract law? Let us look at what I'm talking about. So we are talking about the case of Shua versus Shared Basin Authority. Now, Shared Basin Authority is CBA. The respondent authority, that's Shared Basin Authority, had awarded a construction contract to one company called ACAM. Now, this is ACAM versus CBA, Shared Basin Authority. Good. Now, a term of the contract stipulated that should ACAM fail to perform its contract, it will forfeit its construction equipment to CBA, Shared Basin Authority, the both of them of the contract. Okay? ACAD actually defaulted in the performance of its contract, and accordingly, CBA gave its notice of forfeiture. Oh, no problem. Why? Because it's stipulated in the contract, right? The contract says that where ACAM does rubbish, he go collect, right? So ACAM, if you do rubbish, me, I go collect your equipment, right? No problem. And ACAM did rubbish. CBA, the two contracting parties, ACAM and CBA, right? ACAM did rubbish. Then CBA said, oh yeah, I want to collect. He gave notice. CBA gave notice of forfeiture of its equipment and took possession of them. After this, ACAM purported to sell. Smart guy. He just say, I don't default. Oh, wait here, I go can't do like this. And I said, okay, this is what we are going to do, yeah? So I'm going to quickly sell it and make my money and jackpot run away. So what did ACAM do? ACAM sell the property to who? To Alhaji Shua. When Alhaji Shua demanded for the equipment from CBA, the latter, that is CBA, refused to release them, which is their right. where I had a contract with Akam. If you default, I'll collect your equipment. He defaulted, I collected his equipment. One party that I don't know from Adam, he called himself Alhaji Shua, now wants to come and collect the equipment from me. And in my head, I will now say, yeah, come and take it, because he said that it's my equipment now. Per this contract which I had with Akam, I am supposed to be in possession of the equipment. Shua, I don't know you, right? Good. So when Alhaji Shua demanded for the equipment from CBA, the latter refused to release it, and Shua sued CBA. It was argued that the process under which the equipment was forfeited by Akam to CBA was defective and invalid, and therefore CBA did not have a proper title to the equipment. In my head, when I read that issue, in my head, I was like, is it Shua, who was not there during the making of the contract, who has nothing to do with the making of the contract between Akam and CBA, that can come to court and now tell the court, my lord, there was a defective contract? Who are you? Are you a party to the contract? No. Were you mentioned in the contract? No. So who are you to come to the court and refer to a contract which you are not party to and tell the court that it was defective? The process of that contract was defective and invalid. Do you understand? What did the court say? The Court of Appeal held that not being a party, Shua, not being a party to the contract between Akam and CBA made sure that the appellant could not challenge its validity or implementation. You are not a party to the contract between Akam and CBA, and then you, as an issue brought before the court, you are not telling the court that their contract was invalid. Who are you? Who are you to say the contract was invalid? It is only a party to a contract that can sue on the contract. If you are not a party to a contract, you are not privy to a contract, you are not even mentioned as a third party to a contract, how can you then say you want to sue? What did Okezie, Justice of the Court of Appeal, said? He said that it is a fundamental principle of English law, which is also applicable here, that, look at it, only a person who is a party to a contract can sue on it. Like, that is the only sensible thing. The contract was between Akam and CBA, right? Good. And then Akam defaulted. CBA took possession of the property as it's a term of the contract, right? Then Akam now sold it to Shua. And then Shua is now coming to tell the court that, you see, that contract that CBA had with Akam was defective. In my head, I was like, but who are you? Where you they come from? Ibolotin Jabo. What's your matter? What's your I don't understand. There is a contract between Akam and CBA, and then you from nowhere, you are telling the court that contract is defective. Where is your local standard? Where is your do you get what I'm saying? So the court said it's a fundamental principle of English law, which is also applicable here, that only a person who is a party to a contract can sue on it. That's the only sensible thing now. It's only when you're a party to a contract that can sue. There is no doubt that the appellant, look at it, that's Shua. The appellant was not a party to the contract, right? That's the contract agreement. The respondent knew nothing about the appellant. Yes, CBA does not even know. When he was making the contract with Akam, he does not know who Shua is. When he was taking possession of the property, he does not know who Shua is. It is when he has taken possession that one Shua is now coming and say, oh yeah, give me the oldest thing. The respondent, CBA, knew nothing about the appellant and contemplated no legal relationship with him. The court should be unwilling to allow a person who is not a party to a contract to use its terms in order to secure a benefit which you would otherwise not be entitled to. That is a very simple and sweet judgment. You are not a party. You were not even mentioned as a third party. You are not privy, and then you want to sue on that contract. It's not possible. It's not. Do you understand that? So that is the case of Shua versus CBA, or at least the Chad Basin Authority. In our next case, we are talking about the case of Ilesha Local Planning Authority versus OLAYIDE. Now, another nagging issue that keeps on agitating the minds of many is whether a person cannot take benefit under a contract which is not a party, or be subjected to liability that may arise from the contract. Now, while we are answering this question, we'll be looking at the case of Ilesha Local Planning Authority versus OLAYIDE. The respondent was appointed by the governor of Oyo State under an enabling law as the chairman of the appellant authority. Under the enabling law, the authority could not appoint or dismiss its chairman. This power was vested in the governor acting on behalf of the governor of the state. When subsequently the governor relieved the respondent of his appointment, he turned around to sue the authority for breach of contract and arrears of salaries unpaid after his removal. The action was declared invalid by the Court of Appeal. Although the respondent was party to the contract of employment, the other party to it was the governor of Oyo State and not the appellate authority. The latter, that's the appellate authority, not privy to the contract of employment between the respondent and the Oyo State governor, he could not be sued and made liable for its breach. This is just sensible. Who employed you? Governor of Oyo State. He employed you as chairman of one particular authority. So we have three people. We have that local authority, that's the Ilesha Local Planning Authority. Now, in law, the Ilesha Local Planning Authority is a person in law. Do you understand? Now, another person is the chairman that was appointed by the governor. And then another person is the governor. Now, we have three people, right? Now, who appointed who? Now, is the governor that appointed the chairman, Abi? Now, the governor appointed the chairman of Ilesha. Do you understand? So, Ilesha is a party to the contract, right? Now, when you are looking at it, the governor now relieved him, that's the chairman, of his duties. He now turned around. Who was he supposed to sue? He was supposed to sue the governor for any damages, but he now turned around to sue the planning authority. And then the planning authority, the lawyer for the planning authority now said, my lord, I don't to understand what thing they happen for you. I don't understand why they sue me. Yes, they put my name for inside contract. But shall me make offer of employment? No. Shall me accept offer of employment? No. Shall I offer consideration for this employment? No. I beg, man, I don't to get what they happen for you. Why did they sue me? Then the court said that because he might have been a party, a third party to the contract, because he has furnished no consideration, because he knows nothing about the contract apart from the fact that he is a party, so to say, then he cannot be liable for anything that comes out of that contract. Do you see how the privity is working? When I mean here, I'm talking about the planning authority. The planning authority is a person in law. Do you understand? That is just like a company. A company is a person in law. There are authorities that are person in law. They can sue and be sued. So this planning authority in this instance is being sued. And while it's being sued, you are now asking the question whether or not he's a party to the contract. The answer is yes. He might be a third party. He's not a contracting party. He was not the one that made offer of employment. He was not the one that accepted offer of employment. You know, who made offer of employment? Governor of Oyo State. Who accepted offer of employment? Chairman. Wetin come concern authority wey just be third party. Do you understand? And the court held that the third party could not be made to suffer for any breach. And we have our last case here of Idofueko versus Pfizer product. Now, there is no doubt that the doctrine of privity of contract has come to stay in Nigeria as court has continued to apply it. Even in the most recent case of Idofueko versus Pfizer Products Limited. Now, what happened in this 2014 very recent case? In this case, the first respondent was not a party to a contract between the appellant and Pfizer. So we have A and P. There's a contract between A and P, and the first respondent was not a party to that particular contract, under which the appellant claimed he was entitled to be given stocks. The court held, inter alia is the legal term for amongst other things. The court held, amongst other things, that in this circumstance, the appellant could not sue the first respondent for the unpaid stock option benefits accruing to him. So we've looked at all the cases, on Nigerian law, and now we understand. If there is anything, we can say you can beat your chest like this. Beat your chest and say, yes, you know privity of contract. For you to be privy, you must have been named in a contract and you must have furnished consideration. And being privy means you can sue. Being not privy means you can't sue, so to say, right? Although Professor Kolola Daniels said that the fact that a contracting party had already furnished consideration well enough for you, a benefiting party, to be able to operate on that consideration should suffice. But several courts would not agree with what Professor Dieko Daniels has said. Several courts say that a contracting party has furnished consideration, quite all right, but the benefiting party should also furnish consideration. Although Professor Dieko Daniels has a problem with that, but we have to follow what the courts have said. If we look at all the courts, they now start listing the courts and what they've said. From Price and Listing, Tweedle and Atkinson, to Dunlop Pneumatic Tire versus Selfridge, to Silicon's case, to Beswick and Beswick, to Chad and CBA, to, you can see how I am naming the cases. That's how I want you to be naming the cases in exam. As you are naming the cases, you are saying the court held that, the court held. Be firing the examiner. Let them know that yes, there is substance. Do you understand? So yes, that is it. So at least as of now, if you are talking about the general principles of privity, two things. Number one, question. As a very sound law student, the first question is you should ask: is he privy? The person that is suing, is he privy? Privy could come under two things. Is he a contracting party? What does it mean to be contracting party? Was he the one that made offer, acceptance, or consideration? If he's not a contracting party, then is he a third party? Is he a jus quaesitum tertio? That's third party, right? Now, if he is a third party, the next question you should ask: did that third party furnish consideration? If he's a third party, did he furnish consideration? If he did not furnish consideration, what's the answer? He cannot sue. It is until he furnishes consideration that he can sue. Abi, that's our rule of privity. With all the cases that we've learned so far, I also want you to go and look at the case of Pan Ocean Oil Corporation Limited versus Hamigrati Chemical Company Limited, a 2020 case, very recent. Also the case of John David's Construction Co. Limited versus Raikus Company, a 2019 case. And also the case of Motec Investment Limited and another versus Odemadigi. This case is thick. Or Demadigi. Now, in these cases, I also want you to look at, read it, and when you get to the exam hall, cite them. Let the lecturers know that you have substance. You see, in each of these cases, you would know that when you are talking about the rule of privity, we are asking the question: is he a contracting party or a third party? If he's a contracting party, then he's obviously privy and he can sue because he must have, performed any of the three elements: offer, acceptance, or consideration. Then if he's only a third party, has he furnished consideration? Is he a stranger to the contract or a stranger to the consideration? If he's a stranger to the contract and a stranger to the consideration, then he cannot be termed to be able to sue on the contract. And now it's time for us to look at the exceptions to this rule. There are about 10 exceptions. In short, the exceptions were so much to a point I used to wonder, should this rule still exist like this? Because the exceptions are a lot. But we are going to look at each of the exceptions one after the other. But the first type of exception we are going to start with are the common law exceptions, before we get to the statutory exceptions as is applicable in Nigeria. So what are the common law exceptions to this particular rule, privity of contract? What are the common law exceptions? In my next class, we are starting with the law of agency. And this is where I end with my class for today. I hope that you've enjoyed the class so far. Please make sure that you click the notification bell and subscribe to my channel, and also share with your friends as much as you can, those that you know that it's going to help. And don't forget to follow me on LinkedIn and on Instagram. I will see you in my next class.